about transfer of underlying basis. And the reason we want to talk about transfer of underlying basis is because we're seeing it coming back. There was a time there was a lot of it, and then things slowed down. And the disparity between the EB3 and the EB2, people are jumping back on the EB3. So transfer of underlying basis is a concept that if you are an immigrant, mostly in the employment-based, but really not only for employment-based, listen up, it takes less than 10 minutes. You'll understand it, and it's going to help you out, maybe have an option for you. I'm Sam Shihab with the law firm of Shihab Burke.
Brian Burke from that very same place, Shihab Burke.
So transfer underlying basis is when you are in a certain category, and we're going to expand on that a little bit quickly, and then you move to a different category because it's better for you.
Yeah.
And guess what? It can be done without filing a new adjustment application. Yeah. As a matter of fact, transfer underlying basis can be done between employment and family immigration.
Yeah. And
you are doing
family to employment as well. Yeah.
You're doing an employment case, and boom, you're getting married to a U.S. citizen. You can do a transfer underlying basis. Although I'm not sure I would recommend that, but it can be done. Vice versa, you can move from EB2, EB3, EB1. Special immigrants.
In principle, transfer underlying basis says, let's be efficient with your time and money in filing a case, the government's time and money in filing a case. Let's not make you file another I-45 when suddenly you are eligible to immigrate in another category that might be better for you, essentially.
It's going to save you time, it's going to save you money, and it's going to get you closer to your green card if you understand it well. And a lot of people don't understand this. So what's the first criteria? So let's have an example, because transfer underlying basis is the kind of thing that gets confusing. Yeah. So let's have the most common scenario. Okay. And it is, I am in the EB2 category, my priority date now has become current in the EB3 category, and am I eligible for the EB3 category? You would file an I-140 in EB3, and the moment you file it, because the I-140 has to be either pending or approved. It doesn't have to be approved. Pending or approved. The moment you file this I-140 in EB3, you are eligible to request an underlying basis, otherwise known as interfiling.
Yeah. Tub. We call it the tub around here because interfiling can mean a lot of things. But so to be clear, you have to be eligible in the other category. So again, if the scenario you're describing is kind of like the not the October 2020 category, but it's basically somebody out there has a long pending I-485 in the EB2 category. Well, shoot, EB3 is a couple months ahead. Can I file? Can I take my I-485 to the EB3 category? Yes. Transfer underlying basis. Options for doing it are, if the EB3 I-140 is already approved, you just never made the jump to EB3, you can send a letter and a form to USCIS, form I-45J, and say, hey, move my I-485 from my EB2, from sitting on top of my EB2 I-140, to sitting on top of my EB3 I-140. But like you said, if you don't even have an EB3 I-140 yet, at the same time you file that EB3 case, you can literally write into the case and say, by the way, once you approve this, I would like you to move my I-45 to this EB3 I-140, and that's another way you can affect a transfer underlying basis. Yeah.
So what are the requirements? The first requirement is you must have had a pending adjustment of status that remains valid today.
Yeah.
So what does that mean, and what scenarios where an adjustment of status that you have that may not be valid today?
Well, what adjustment of status that's denied, essentially, and really...
Or an I-140.
Well, yeah, so an I-140 being denied that's underlying an I-45 is the most likely way to kill an I-45, employment based in my opinion. So if there's a scenario where, shoot, they killed my I-140, that's going to kill your I-45 as well, you can't revive that after the fact with a transfer underlying basis.
So you're with an employer, they withdrew the I-140.
Yep.
Next day, after the USS received that, you cannot do a transfer underlying basis using that adjustment status because they withdrew the I-140.
Yeah, presuming you're in a scenario where the I-140 actually kills the I-45. Obviously, there's portability scenarios, which is different from transfer underlying basis, which is something we should emphasize, that under which an I-140 withdrawal won't kill your I-45. But it's really, if you file your I-140, I-45...
Assuming no portability.
Yeah, assuming no portability, which is really, you are in the first 100, if you file I-140, I-45, no portability for 180 days and really not a good idea until your I-140 is approved. That's kind of the scenario you're talking about. Yeah.
Okay. So the continuing eligibility of adjustment status is the number one criteria. Now, eligibility for adjustment status is one thing, and then the second requirement is continuing the pendency of the adjustment. It's very similar, but it really means that you did not withdraw the I-45.
Yeah, you can't have said, oh, I withdraw this for whatever technical reason and revive it by sending a letter. Once your case is toast, it's toast. You can't
eligibility really focuses on the I-140 underneath it, and the pendency, the adjustment status focuses on the adjustment. Both have to be in good shape.
Yeah.
Both have to be not withdrawn, not denied. So that gets you into, okay, we need to look at what we call is the substituted category.
Yeah.
So the substituted category is the new category. In our example is going to be the EB3. Yeah. Okay. Are you eligible?
Yeah. And that kind of raises the question of, do you do it at the time of filing the I-140 EB3, or if you already have the I-140 EB3 approved? If you have an I-140 EB3 approved already, you're eligible for the category. That's what that I-140 is about, bottom line. It's a requirement, but it's not one that's hard to meet.
Or if you have a pending, meaning you just file it at the same time.
Yeah.
Okay.
Yeah. So you're about to establish eligibility. Once they approve the EB3 I-140, you're going to be eligible.
Now, the big one where people miss.
This is the one that frustrates me the most because there's bad advice going out here.
A lot of people don't understand this. So your EB3 priority date must be current.
Yeah.
The final action date.
Yeah. Because government policy, if you're wondering where Sam and I are looking right now, we are looking at the USCIS policy handbook excerpt on this, and the requirement is visa immediately available. Visa immediately available, like you said, means final action date current on the visa bulletin. Dates for filing does not mean a visa is available for you. Final action dates mean if we had your case in front of you right now and your final action date current means we could put a green card in your hand if we wanted to. Yeah. Final action dates current is not the same thing. Final action dates means we could accept a case, but we don't have a visa available for you until the final action date is current. And that's a requirement for,
What's the next requirement, Brian?
You're one step ahead of me. It's discretionary. In theory, the government doesn't have to give you that benefit, right? And there's a set of criteria, but I have never been I can't recall ever being denied a transferred underlying basis request when it suits somebody to get them a green card faster. I've literally gotten calls from USCIS officers saying, hey, I have your client here. Their I-485 is eligible in the EB2 and the EB3 category. Which one do you want me to prove it in? They don't really care that much. And my answer in that scenario, and the couple times I've gotten that call, is whichever category you can do it for them immediately right now. They don't really care. It's not a contest in terms of category. It's a contest in who gets getting your green card as soon as possible.
So the request must be in writing.
Yeah.
It's in the category, meaning that you cannot just make a phone call.
Yeah.
Petition considerations, they're saying that it may be a situation where if your prior case is about to be approved and now it's getting approved, we're not going to stop it.
Yeah, exactly. Why would I do the extra work to move your I-485 from, hypothetically from EB2 to EB3 if you're current in both categories and I'm about to approve the case? That's a scenario where I trust their discretion. Ignore obstacles. Basically, I think the discretion policy says don't waste everybody's time in affecting a request if it's silly for us to do so, Yes.
Yeah. Now, where are the downsides or where are the frustration points in the request to transfer underlying basis or to interfile?
So one thing that a lot of people forget about is that when you do a transfer for underlying basis, it resets the portability time frame, the 180-day portability requirement. So maybe let's talk about
what's that?
Yeah. So first of all, transfer for underlying basis must be distinguished from I-45J portability. I-45J portability is the concept of once your adjustment of status has been pending for 6 months, and ideally you should have approved I-140, you can take a new job offer of permanent employment from another company, and that can be the path to you getting a green card without having to do a new I-140, new perm. It's basically any other company that's willing to offer you permanent employment in a same or similar occupation in the United States. I-45J portability.
And that requires 180 days from the date of filing the adjustment of status application.
Yes.
Okay. once you do an underlying basis,
Tub, yep.
the 180 days
Reset.
resets,
Yeah.
meaning that you have to wait another 180 days to be able to exercise the portability requirement under the new category.
Yeah.
So, for example, you're on EB2, you're on day 170, and then you file a transfer underlying basis to EB3, and you mail it. You cannot change jobs in 10 days using portability. You must now wait a fresh 180 days to be able to change jobs under this I-140 that is an I-45 that now has been pending for 170 days plus 180 days on top of it.
Yeah, which means there's some kind of risks in doing the tub because, if your job goes up in, the basis for your I-140 EB3 goes up in smoke, for example, it can be a challenge.
You can do transfer underlying basis one time per adjustment, except for employment, they allow you to do it for more than one time.
Yeah.
Now, the question
employment-based first, second, and third categories, amongst those.
Yeah, so the question I have for you, if somebody goes to third category and find out they're losing their job, and he goes, oh no, let me transfer back to EB2, again, with another transfer underlying basis, do you reset the 180 days or you get a fresh 180 days?
Maybe I'm not understanding your question, but it is making me think about something that is a frustration, something you need to understand about transfer on an underlying basis. You can't do it without the permission of the employer that owns the underlying I-140. People, maybe one of the most common questions I can get is, okay, I'm in the EB3 category, I use portability, now with, I went from company A to company B, and now I want to go back. It turns out, company A also filed an EB3, I transferred underlying, I used portability to leave pursuant to a 45J portability, but they also had an EB3 for me. Now my EB3 dates are better. Can I just do a transfer underlying basis back to EB3? Not without the support of that employer. They have to sign off on a form, I-45J, to do that, I guess.
And it has to be also an intent to hire.
Yeah, of course.
Get a green card, which is...
So maybe that wasn't the question you were asking.
No,
but.
So the question I'm asking is, and I don't want to digress too much, we took too much time, is 170 days,
Yep.
You're on EB2, you do a transfer underlying basis to EB3,
Yep.
Now you reset the clock.
Yep, agreed.
Okay, now you have 180 days to do a portability because you transferred your underlying basis to EB3.
Yeah, sure.
Yeah. Now, 40 days later, I want to go back to EB2.
I don't believe there's such a limitation on transfer to underlying basis.
Do I have a new 180 days, or the old 180 days?
I think if you are,
there's no answer to that question.
You are going off the rails, and I'd say off the rails. Your conservative advice, presume a new 180 days.
Yeah. There's no answer to that question. Yeah. The rules not good, but you have to assume that.
Yeah.
Yes.
I think the last thing I want to bring up is you're talking about downsides.
Yes.
Right. People get frustrated by Tub and I-45J portability, frankly, if the government doesn't give you good information about it. You don't get
because
notices.
There's no filing fee.
Yeah.
Because there's no filing fee associated with it, you don't know whether the government, approved it, disapproved it. It's a very difficult. You're kind of in a limbo. And if you did it incorrectly, they're not going to tell you did it incorrectly, and that's the biggest problem. So let's assume you file the transfer underlying basis, and the category you're going to was not current at the time.
Visa was not immediately available.
Yeah, Visa
Final
was
action date not current.
Yeah, was not available. They won't tell you that.
Yeah.
They never tell you that until, 3 years later you go, oh boy, I didn't transfer my underlying basis after all.
Yeah.
And now what is the consequence of that? God knows.
Yeah, I mean, do they just affect it when your party date does become current? Maybe, but you don't know.
Yes.
Sure.
Yeah. So that's what transfer underlying basis in 10 minutes plus a couple more minutes on top of it. And we will take your questions here and bring them on. We have immigrationquestions.us in there. That if you drop the question there, we will bring it. And if you post your questions live here, we'll bring them. We get a few more minutes here today, and we will do the best we can to answer your question.
Yeah. I know we have at least one here from Immigration Questions. Hey, we got a couple here from immigrationquestions.us, and one we didn't get to until right now is one from we wanted to get you last time. We just did not have the time to it. So I'm going to try to get it up here on the screen right quick by pushing a couple buttons here, and darn it. Well, I'm going to have to sort of put the last part of the question, and I'll read the first part aloud, and we'll get it up here. So this full question here is, I have an approved EB2 I-140 petition with a priority date of February 2021, a date which is current for EB1A India. Can EB1A I-140 and I-45 applications be submitted together on the assumption that the priority date will be ported from EB2? So, yes, you can. Well, you don't have to assume that the priority date is going to be ported. You request the porting of the priority date in your I-140 filing.
Well, you assume, but you assume correctly. Yes, you own that priority date. It's yours, and you can definitely file your application with the understanding that this EB2 priority date is yours and will be used for the EB.
Yeah, I just filed an EB1A I-140 on Friday.
You just don't like the word assume.
Oh yeah, I mean, well, you don't have to assume. If you put in a request in the letter and say, hey guys, I have a prior I-140 priority date for my EB2 case. Can I please retain it here? Yeah. And you do.
Yes.
You know?
Yes.
Let's see here. Another question here from immigrationquestions.us. So again, I'm going to have to sort of abridge it here to fit it on the online thing here. But oops. Here right quick. So the full, I'm sorry, Sam, I'm not giving you the benefit of being able to see it.
No problem.
The question here is, my dad is 81 and recently had his naturalization interview on July 2nd, 2025. It went well. They asked for a copy of his birth certificate, but he doesn't have one. And the question that we have here, and I should be putting it up, is there a form that we can submit that would waive this requirement?
Number one, most likely they have a copy of that birth certificate if it's ever been available, because he filed for a green card law.
That's a good point.
And to the extent that he did not have it, they've accepted secondary information, secondary evidence.
Well, what you're saying is that in this person's green card application, presumably about 5 years ago, they would have had to do it.
He's 81 years old.
Well, yeah, but okay, at least 5 years ago.
40 years ago.
At least 5 years ago, because the general requirement.
Yeah.
But the bottom line is that they would have asked for a birth certificate as part of a green card application, and if you didn't have it, you would have given them alternative evidence like affidavits and evidence of their birth.
Right.
And so that's the sort of thing you start with, but.
It all depends on how much time they give them, usually 30 days.
30 days, that's the challenge on a notice of continuance for a citizenship case.
So I think you need to probably throw in as much secondary evidence as you can. You might want to engage an attorney quickly to kind of help you put this together, because if you do not satisfy them or show them that you've done everything you can, your father may not be approved. So.
Yeah, the rules for this, my question is ultimately, is a birth certificate available at all? And for certain countries, birth certificates are presumed unavailable based upon certain ages. And the most common one I know off the top of my head is, if you look up the Department of State, is for India. For people born, I think it's before a time in 1970, the Department of State says birth certificates are not available. We accept the premise that you cannot provide a birth certificate for people born before that date. So it's really, I guess the point I'd bring up is the Department of State has sort of a policy called the civil document availability, sometimes called the reciprocity tables, that basically says for any country in the world what kind of documents are available.
And not available.
Yeah.
And not available. So that is where the starting point usually is. And they're not going to look it up for you.
Agreed.
They're not going to look it up, as they should, but they don't. So you can start there. Most likely your dad, who's 81 years old, I bet you there's going to be somewhere there that says record prior to 1951 or something, were not recorded or do not exist, whatever.
And that's a scenario under which you give secondary evidence, which is like affidavits, school records, government records, medical records, things that would have the same sort of information that would appear on your birth certificate. But I agree with you, Sam. That's the sort of thing you might want to talk to a lawyer to basically make sure that you have shown the government that you jumped through all of the hoops necessary to show that you can't provide it if you cannot.
Countries go through wars, Brian, and wars burn government buildings. and government buildings contain papers, and there were no electronic record at the time. So there's all kind of evidence you can present as to the unavailability of these documents, and then what other document you can provide to give them evidence of the birth. So yeah, a little bit of effort in done, but you probably need a lawyer on that one. All right.
Well, I'll hit some of the last questions we have
sure.
here. So, well, some of these questions about a consultation I had with somebody today, and what I'm gonna tell that person is I'm gonna send you an email and answer your question on the follow-up, because I don't think it's the appropriate venue here to talk about the personal details of your case. But I thank you for tuning in, and it was a fun conversation we had today. That's for sure. From Sandfax, frequent viewer.
Hi Sam, Brian. My I-45 filed in 2020 by employer A under EB3, and in 2022 he did a transfer of underlying basis to upgrade to EB2. In 2024 I moved to employer B. My priority date is current under EB3. As of August, Visa Bulletin, how do I request USAS to consider my case in EB3? Do I just write a request letter? So this is exactly the example. This is exactly the example you just gave. That is people confuse it with. So I'm going to give you the floor to explain it, Brian.
Okay. So I need to put the facts up here again. So employer A in 2020 filed an EB3, and in 2022 they did a transfer on another basis upgrade to EB2, right? And then in 2024 I moved my.
And then after 180 days have passed.
Yeah. I used the supplement J portability rules to move myself to an employer B, and presumably what that I-45J you did to do a portability request to employer B is going to say, yep, I'm in the EB2 category. Here's my EB2 I-140 approval notice. Take my EB2 employment to company B. And the problem you have right now is if your EB3 approval, I-140, is with company A, you need company A's support in order to go back to the EB3 category. You're interpreting the question the same way I am?
I am. So what is needed by the first employer, Brian?
What's needed from Sandfax? It is charm and charisma to go back to company A and say, guys, I'd love to be in the EB3 category, and I'd love to be in the business and being with you. Would you guys be willing to support a change of transfer to underlying basis for me to come back to the company to get my green card through you a little bit faster in the EB3 category?
Assuming the I-130 is now withdrawn.
I-140, but yeah.
I-140 is now withdrawn.
Yeah.
And then so you.
Well, Sam, they can refile the I-140 in EB3. If they withdrew it, they can file it again.
It's pending, and you file it. Now, 180 days after that, if things change and the green card, but he has to go back and join the employer, right? Because if
he doesn't have to go back, but in USCIS, they do love a scenario where you're not
issuing a green card now.
Yeah.
It's
you will have to go back when you're current. Agreed. You have to go back.
Current. So they may just say, come on in for an interview. We want to talk to you about this transfer underlying basis to EB3.
So I'm splitting hairs saying, well, Sam, gee, you don't have to go back until a green card's in your hand, but a green card's about to be in your hand. You're right. You should go back. Yeah.
You must go back. Otherwise, if you go to the interview and say, I'm going to wait until I get the green card, or I'm going to go to this employer. No.
Yeah, okay, I agree. I'm technically right, you're practically right. I agree with you. Yeah.
So I-140 filed or available, you do a supplement J, you transfer to EB3 underlying basis with a future employment with employer A. Right? Mm-hmm. Now, if the green card is issued within 180 days, you got to get your butt over there, man.
Yeah. And
start working there and showing that you're working there and have an offer of employment or a confirmation. They would like to see the actually start working there. Yeah. You cross 180 days, you could take this EB3 and transfer it to employer B.
Yeah. Now, I'm sure employer A is going to really love you for that scenario, but yeah, you can do that. Yeah.
Yeah. But he's still working for employer B. Yeah. I mean, it's dicey.
Yeah.
It's dicey. So, but that's the answer.
Yeah. The answer is you can't. The short answer, Sandfax, is you can't get back into the EB3 category without employer A's support for a transfer. They have to sign a 485J for you for that.
We like questions on the topic we discussed because we can talk about it
Yeah,
more.
it makes me do things like that. That's for sure.
Sam and Brian, my daughter's category is F1 in family-based. Okay, first preference F1, which is I think.
I can never remember what they're called. I will admit I need the visa
Yeah.
bulletin to remind myself which
I
one.
think, yeah, of a U.S.
F1 is,
citizen, yeah.
yeah.
Family-based. She is Canadian citizen, country of birth, India. Documentation submitted and completed, and just waiting for the interview.
Priority date June 17. Last time she wanted to visit the U.S. CBP officer denied her entry, saying she won't return back. Got her to sign a withdrawal of entry report. Gave her a documentation. Sorry, Sam, I took over to show ties and apply to come back in 6 months. It's been a year. She genuinely only wants to visit the U.S. What are her
Show ties.
options?
Okay, to show ties to the home country, to
Yeah.
back to Canada.
Yeah.
All right, so I just had a meeting today with a gentleman who wanted to bring his kids to the U.S. For a wedding, and he's a U.S. citizen. Very similar scenario on this. And what I did is what I will do for this person or anybody on the visitor visa is I draw a line and say, let's talk about the pros, the good stuff. Let's look at the bad stuff. Why the USCIS or the U.S. consulate may or the border may deny. Why should they approve?
Sure.
And you list both of them, okay? And then once you list both of them, you can figure out what are the chances. What I tell people is you gotta take it on a scientific basis, and you gotta organize a documentation to show ties, to show good faith, etc. And typically ties is a job, marriage, education, and so forth and so on. And do you need a lawyer for this? Maybe. We help a little bit. We don't really make a case that's absolutely not approvable, but we can probably save you a lot of time by looking at it and say, no, it's not going to work out, or yeah, you have a chance. Yeah. But yeah, that's how you do a case like this.
While you were going through your pros and cons, I went ahead and pulled the visa bulletin for August and looked at this person's priority date. They have a priority date of June 2017, right? And for the month of August 2025, which we're just about to enter into, right? They are accepting dates for filing for family-sponsored adjustment cases, and the F1 category.
Born in India.
Is
same date.
Yeah, that's the F1 category. The priority date is 1st September 2017.
Yeah, they know that problem.
That priority date's current, and that's going to be a big problem for the folks at the border, because if they can put that together, which they oftentimes can't, as an aside, but they can put together that, shoot, she could file for adjustment of status if she's in the country right now. That's a very good reason for them to deny.
Now, there could be, so are you saying confirming in fact it's current?
Yeah, priority date is June 2017. Current families date for filing, which you're accepting for now, is in September 2017.
Now,
they're eligible right now to file.
So that leads me to one more comment, that if you don't act on that within a year, this I-130 that you filed could be canceled.
Yeah.
So if you acted on it, that's the more reason for the officer. I will put that on the column of why it's not going to be approved, because your immigration is imminent.
Yeah, I mean, they've acted on it. As per the notes up here, they say, and just waiting for the interview, and they're waiting for an interview. Basically, the Department of State already contacted them to say, get it going, and they just haven't interviewed them because the priority date is not final action current yet.
This is one of the cases I would say the chances of your daughter coming here are not very, on a visitor visa, are not very good. It's just your case is so eminent, and that's not something that I would want to even risk getting an officer exercised over her attempt entry, and they can do some stupid decisions.
Yeah, I mean, go back and check the video. Your eyes lit up when you saw they were given the denied her entry. Denying entry and being allow you to withdraw entry, that's not so bad. It's that's a nice version. We're not gonna let you into the United States, but we're gonna just allow you to take back your request and say adios to you. But if you, for lack of a better word, piss them off, they can say, we're going to expedite remove you, and that's going to cause big problems.
Yeah, expedite removal can be very bad. So what's the basis for expedite removal? Fraud.
Yeah.
Not being forthcoming. So, you didn't tell us this, or you tried to trick us. So my suggestion is I would keep your daughter away from the border, wait for the interview, and put your energy and your resources in that direction.
Yeah.
That gets us into the end. If there's one more question, we'll take it. Otherwise, we will
I think
conclude.
we got them all here. Again,
right.
I owe a nice person an email about a consultation we had today, but beyond that,
All right, wonderful. We'll see you guys.